Hello, everyone, and good afternoon, evening. Welcome to this side event titled Civic Space Obstructed, Fundamental Freedoms in Singapore Through the Lens of the Universal Periodic Review. This event is organized by Forum Asia, the International Commission of Jurists, Human Rights Watch, CIVICUS, World Alliance for Citizen Participation, Access Now, and Forum Asia's member Think Center. My name is Icayan, and I'm from Forum Asia, and I will be moderating this event. We are holding this side event ahead of the formal adoption of the outcome of Singapore's Universal Periodic Review. We will be joined by civil society actors who are working extensively on the issues of human rights and civic space in Singapore. We're also using this side event to highlight the international community the need to continue to monitor the civic space situation in Singapore and emerging space, and to act to hold discuss this more with Civic and ASEAN SOGI caucus, focusing on advocacy for civic space and fundamental freedoms. Hanung, you have the floor for 15 minutes. Thank you.
Thank you very much, Joy, for the introduction. Am I audible? So good morning and evening, everyone, from wherever you're joining. My name is Hanung. I'm the Advocacy and Campaign Officer for CIVICUS, in charge for Asia. And today I will open the session by presenting how Singapore has been engaged with the UPR and its relation to the situation of civic space within the country. But before moving forward, next slide, please. Let me just introduce you on what CIVICUS is. We are a global alliance of civil society organization and activists dedicated to strengthening citizen action and civil society throughout the world, with more than 9,000 members in more than 175 countries, and headquartered in Johannesburg in South Africa. And from our perspective, when we are defining what civic space is, we see it as a foundation of open and democratic society, a condition where people and civil society organizations are able to organize, participate, and communicate without hindrance and claim their rights and influence the political and social structure around them. So having said so, the importance of freedom of expressions, association, and assembly as our as the foundational matters of civic space, and as our focus as well, is very important, and it will be my focus as well for the presentations. And one of the tools that CIVICUS has is the CIVICUS monitoring, where we monitor and update the situation regarding development related to civic space on countries across the world, and rate it based on the category of open, narrowed, obstructed, repressed, and closed. If you're really interested on knowing what are the definitions and how we rated it, I would like to suggest you to visit the CIVICUS Monitor website later on. Next, please. So what about the situation in Singapore? So basically, CIVICUS rated civic space in Singapore as obstructed, as it is heavily contested by power holders, by the continuous utilization of legal and practical constraints to hinder the full enjoyment of fundamental rights. And what kind of legal and practical constraint in these say? It can be in the form of use of bureaucratic harassments, undermining public statements, restrictive media environment, and so on and so forth. And from our documentation, I just want to mention some of the restrictive laws that we did so far. And on freedom of expression, for example, Singapore has a Sedition Act that criminalize speech that has tendency to bring into hatred or contempt or to excite disaffection against governments. And also Singapore has criminal defamation provision under section 499 to 502 of the Penal Code to prosecute critics. And then there's also the existence of the 2017 Administration of Justice Protection Act, which is a vaguely worded contempt court of law that has been used to prosecute HRDs for criticisms of the court under the guise of protecting the judicial systems. And then very well known that Singapore also have a POFMA, which is the Protection from Online Falsehood and Manipulation Act to harass the political oppositions, activists, journalists, and civil society. And also there is a ongoing development on the recent bill that currently being discussed, which is Fika, the Foreign Interference Countermeasure Act, that can be utilized to limit funding of civil society and to shut down independent media. And on the Freedom of Assembly, Singapore imposes Civil Societies Acts that requires all CSOs to register, but the register can be denied and based on arbitrary reasons, for example, in contrary to the national interest or for specific societies to be registered, or is identical to that of any other existing societies, or in the opinion of the registrar is undesirable, just can be sounds arbitrary. And then there is also 2009 Public Order Act that could peaceful gatherings. And last but not least is the last one is that can be utilized to serious violations and large public disorder, which is the public order and safety special powers. And all of these have been utilized to repress HRDs, activists, political oppositions, media, decent protester, trade union, LGBTIQ people, and to name a few. I will not go into deep into these examples because the next presenters will be discussing on this comprehensively. So I would like to talk about the more on the UPR. So before going deep, maybe just a refresher for everyone that UPR is a peer review mechanism where a state concerned need to present how it has how it has conducted to promote, protect, and respect and to fulfill human rights in accordance with international human rights standards in front of other states once in every 4.5 years. And from the dialogue, other states can provide recommendation on how to improve the right situation in their countries, and the countries concerned then can decide the recommendations made by commitment for the recommendations, or they may note it of the recommendations, meaning that they do not want to make a political commitment in this regard. And so on the UPR itself, I would like to speak about on the second cycle, that this is the review that actually Forum Asia and CIVICUS conduct together. In the last review in 2016, Singapore received 22 recommendations on civic space and supported only 8 recommendations. As you may see later on the following slides, all the recommendations Singapore supported include a commitment only to ensure and consider, while they avoid to make commitment on action-oriented recommendations, such as to review legislations, decriminalize reform, take appropriate measures, and to end discriminatory practices. Next slide, please. Okay, and on the second cycle of the related to freedom of expressions, while it was in support of recommendations to consider the necessary legislation and policies to ensure freedom of associations, Singapore did not make any commitment on the call made by Italy and Canada to review existing legislation and practice, such as on anti-defamation laws and registration process of CSOs. Although it keeps citing that in the Article of 14 of the Singapore Constitutions, stating that all citizens of Singapore have the rights to form associations, but in practice, the practice is far from equal, as no further actions to ensure the implementation of the recommendations and the Societies Act. It's always been used to limit civic space and to limit fundamental freedoms in their countries. And next. And on freedom of expression, Singapore notably decided not to support recommendation made by Belgium, Czech, Latvia, Mexico, Canada, USA, Japan, and France to decriminalize, to revise and review media laws and practice of judicial restriction, and to take appropriate measure to ease restriction on freedom of expressions. And instead, the utilization of sedition acts, criminal defamations in the penal code have always been used, and In 2019, notably, Singapore created POFMA to further undermine critics against the authorities under the pretext of preserving harmony in the society. And next. And similar of the previous two on the freedom of assembly, Singapore did not support the recommendations to review and repeal legislations. And despite these legal guarantee made in the constitutions, the government has put in place a number of stringent limitation on the rights. And such restrictions have had a chilling effect on the freedom of peaceful assembly. And then it's the continuous exercise of Public Order Act and the Public Order and Safety Special Power have been observed as well. And in all of the case, as a defense, government of Singapore always asserted that all citizens of Singapore have the rights under the constitutions, but in reality, the restrictions are far more greater than the guarantee of such a protections. So what happened in the current adoption of the UPR in 2021? Next slide, please. I would like to inform that from the 21 recommendations that Singapore received related to civic space, in this year, Singapore only support 4 recommendations, which is a decrease from the previous cycle. And again, as you might see in this slide, the 4 recommendations are actually similar with the recommendation that they received in 2016. But here, Singapore put 2 recommendations under partially supported under the reason that because it contains wording or provision to take measure and to eliminate media censorship. And in the adoptions, Singapore also mentioned that it take a balanced and pragmatic approach to content regulations. So what kind of recommendations Singapore noted for this cycle? Next. I mean, on freedom of express, on associations, it decided not to support the recommendation made by Poland and Iceland, which is to implement measure to increase protection in law and practice for freedom of expression, assembly, and associations, and then to amend the legislation that restrict the freedom of associations in a way. And then next one. And in the freedom of expression, it is notable that various countries have made recommendations related to revise, amend, or repeal, or take measure related to the current discriminatory law against freedom of expressions. And then even 5 countries, which is Canada, Denmark, Germany, Ireland, and Norway, make a specific reference to POFMA, but Singapore decided to not in support with this recommendations, and they only took note of it. And the next, please. Okay. And on the freedom of assembly, decided not to support the recommendation to amend Public Order Act, also to amend legislation or end the use of legal administrative sanction that curb freedom of peaceful assembly, and decided also not to support the recommendations asking for the implementation of measures to increase protection of freedom of peaceful assembly. Next. And these are the arguments that Singapore made during the adoptions. Some to be cited is mentioned that our laws and policies on the rights to freedom of expressions, peaceful assembly, and associations comply with the relevant international human rights law. And then it took balance on and pragmatic approach to content regulations. And then again, last but not least, on the recommendation, on the argument, while it's assured that the right is guaranteed under the constitutions, but again, it reciting again the reasons to preserve a harmony society, and saying that in Singapore, multiracial and multi-religious societies, so that a balance must be struck between individuals' freedom of speech and rights. But in practical, the restrictions are more leaning toward those who convey criticisms against the governments. Next slide, please. Okay. So we actually back to square one back in the 2016, as Singapore decided not to moving forward and keep its approach. And even worse, now there's despite of in addition to their not adopting recommendations to repeal current discriminatory law, there's still ongoing discussions on Fika, which next presenter will discuss about it, and its legal and political implications. So basically, despite its commitment to uphold civic space made in the UPR, as they mentioned, it is evidential that the government has persistently failed to address restrictions of the civic space. And it's been a clear pattern that we have observed on the continuous use of restrictive laws to silence dissent, targeting human rights defenders and political opposition and the media. So moving forward, we might need to think of how to make Singapore move forward from merely assuring and considering for the two previous cycles to finally implement. And I think this is the role that member states and civil society needs to push. And yes, UPR is political commitment, but if there is no commitment to begin with from the country concerned, it is hard to hold it into account. So there are several recommendations that we can think later on, perhaps how member states and civil society can work together to push Singapore and to monitor the implementation of the UPR. Recommendations, for example, how it will take measures to foster a safe and enabling environment for civil society, and then to keep pushing for Singapore to put positive measure for protection of human rights defenders and refrain from doing further judicial harassment and intimidation against them, and then foster meaningful participation of civil society to engage with the states, establishing national human rights institutions, and also to engage constructively with the UPR, international mechanism, including to extend an invitation to the US Special Rapporteurs and to ratify ICCPR. Only with that, we can work together to bring Singapore to move forward and to engage constructively in the UPR and other international human rights mechanism that we have. With that, I would like to end my presentations. Thank you so much. Back to you, Joy.
Thank you so much, Hanung, for giving an overview of the recommendations during the second and the third cycle, and raising how the Singaporean government has not accepted regulations related to freedom of expression and freedom of peaceful assembly and association. Perhaps to go above peaceful, Linda is in watch, focusing on legal for the U.S. Justice Department in New York, where she served as a coordinator of civil rights prosecutions and then as deputy chief of the Organized Crime and Drug Enforcement Task Force. She has taught U.S. criminal, constitutional, and civil rights law at Gakushun University in Tokyo, and co-headed a program to provide pro bono legal services to foreign workers in Tokyo. She's a graduate of University of Virginia and Harvard Law School. Linda, thank you.
Thank you, Joy. Good afternoon or evening, everyone, depending on where you are. I'm going to talk more specifically about some of the laws that restrict assembly in ways that we view as incompatible with international legal standards. Singapore says all of the laws on speech and assembly that they have are compatible with international standards, but we would respectfully disagree with that. I'm also going to give you some examples of how laws have been and have been used against activists and critical voices in recent years. I'm first going to start with the Public Order Act. So talk a little bit about freedom of assembly, which is very intimately tied up with freedom of expression. The government maintains incredibly strict restrictions on the right to peaceful assembly through the Public Order Act, which requires a police permit for any cause-related assembly if it's held in a public place, or even if it's held in a private venue if members of the general public are invited. The definition of what's treated as an assembly is extremely broad. Those who fail to obtain the required permits face criminal charges, even if the assembly was peaceful and caused no disruption of public order. The Public Order Act is particularly restrictive when it comes to foreigners. The police commissioner is authorized to reject any permit application for an assembly directed towards a political end, which is a very broad term in Singapore, if any foreigner is found to be involved. And since 2006, assembly is unlawful and can resent organizer privilege, and its exercise should not be subject to the sort of strict and stringent and restrictive prior authorizations put in place in Singapore, nor should anyone be held criminally liable for organizing or participating in a peaceful assembly. And finally, the Human Rights Committee has made clear you don't lose your right to freedom of assembly simply by being a foreigner. So the restrictions on participation by foreigners and the restriction on their ability to peacefully protest is also inconsistent with international legal standards. The restrictions of the Public Order Act make it extremely difficult for those seeking to speak out on what are viewed as controversial or difficult issues to make their voices heard. And the punitive nature of the law discourages most from even trying. I'll give a few examples just to show how the law has been used against critical voices in recent years. Activist and social worker Jolovan Wham has faced multiple prosecutions under the Public Order Act. So what has he been prosecuted for? He was prosecuted for organizing an indoor panel discussion on civil disobedience and social movements, at which Hong Kong activist Joshua Wong was one of the speakers, because he didn't get the required police permit. He served 10 days in jail in lieu of paying a fine after his conviction in that case was affirmed on appeal. He was prosecuted for organizing a silent protest on Singapore's public transport, in which he and several others wore blindfolds and held up copies of a book about the arrest and detention of 22 activists and volunteers under the Internal Security Act to commemorate the 30th anniversary of those arrests. In that case, he pled guilty to the Public Order Act charge and 2 other minor charges in February this year and was sentenced to a. He was prosecuted for briefly holding up a sign in front of a courthouse and taking a photo before entering the courthouse. That case was tried in August of this year and there's not yet been a decision. And most absurdly, he was prosecuted for standing a placard with a smiley face drawn by who were under investigation. He's not the only person who's been prosecuted for essentially solo acts as being unlawful assemblies. In October 2018, artist Silan Pele was convicted of conducting an illegal assembly for standing alone outside Parliament holding a piece of art to commemorate a former political prisoner. And the 2 young climate change activists that Wham went to support were being investigated because each had posed for a photograph holding a sign and had posted the image on social media as part of the global Fridays for the Future movement. These few examples make clear just how draconian the restrictions on assembly are in Singapore, how inconsistent they are with the right to freedom of assembly, and how they can and have been used to silence critical voices. The rapporteurs on freedom of assembly, communication rights of an association. And yet, as Hanung noted, Singapore has declined to support recommendations that it amend its legislation. Similarly, Singapore has a range of overly broad laws that can be and are used to penalize peaceful speech in ways inconsistent with international standards for protection of that right. The Administration of Justice Protection Act, which came into force in 2017, provides penalties of up to $100,000 and 3 years in prison for several forms of contempt of court, including the archaic offense of scandalizing the judiciary. Speech violates this provision if it imputes improper motives to or impugns the integrity or impartiality of any court and poses a risk that public confidence in the administration of justice would be undermined. Unlike common law contempt, it doesn't require that the speech pose a real risk. All that's required is that it pose a risk, however remote, of undermining confidence in the administration of justice. The lack of clarity on what might be considered to pose a risk of undermining confidence gives broad discretion to the authorities to decide what should be treated as contempt and who should be charged with contempt, and leaves wide scope for the use against speech simply on the basis that it's critical of the court and its rulings. 2 recent examples. In March 2020, the Court of Appeal upheld the conviction of Jolovan Wham under that law for stating on Facebook that Malaysia's judges are more independent than Singapore's for political implications. He served a 7-day jail sentence in lieu of paying a $5,000 fine. The court also upheld the conviction of John Tan, vice chairman of the Singapore Democratic Party, for posting on only confirms that what he said is true. The Administration of Justice Act is also one of the many laws that's been used to target the online citizen, one of the few independent media outlets in Singapore, and its editor, Terry Hsu. In August of this year, the Attorney General started contempt proceedings against Hsu over the portal's republication of a blog post critical of Singapore's legal system. In September, Hsu filed an application for judicial review, arguing that it's irrational to proceed against him when the Attorney General has not acted against the actual author of the blog. That case and the application are still pending. The Human Rights Committee has stated that all public figures, including those exercising the highest political authority, such as heads of states and government, are legitimately subject to criticism and political opposition, and that states parties should not prohibit criticism of institutions. Several states recommended that Singapore amend the Administration of Justice Act, but it did not support those recommendations. Public figures in Singapore have long used civil defamation suits against political opponents and critics. Criminal defamation and defamation laws should in fact be repealed, but civil defamation is what is actually used most often, in part because the courts in Singapore award very, very large damage awards in defamation suits involving public figures. So Singapore defamation law, in contrast to that in many other countries, doesn't provide a qualified standard of proof where the person that is suing is a government official. And the damages, as I said, that are awarded are often crippling high. The repeated awarding of high damages against the government has had a severe chilling effect on critical speech in Singapore. In two recent current activists, Leong Se-hun, without comment, wrote the article, was not sued. He was paid 133,000 Singapore dollars in damages. Prime Minister Lee also sued Terry Hsu for defamation after the online citizen published an article about a dispute between Lee and his siblings about their family home. In September of this year, both Hsu and the author of the article were found liable, and the court awarded Lee 210,000 Singapore dollars in damages. To protect freedom of speech, Singapore should be pressed to revise its civil defamation law to impose a higher standard on public figures in bringing defamation suits, and to give preference to the use of non-monetary remedies, such as apologies, rectification, or clarifications, and to ensure that any monetary award is strictly proportionate to the actual harm caused. And then there is POFMA. In 2019, Singapore enacted the Protection from Online Falsehoods and Manipulation Act, which allows a single minister to declare that online content is false and to order it either removed or the placement of a correction notice on the relevant pages if, in the minister's view, doing so is in the public interest. The law applies to digital content that's accessible in Singapore, regardless of where it was posted, and to platforms such as WhatsApp and Signal. The law has a broad definition and somewhat circular definition of what is false. It applies whether it's false wholly or in part, on its own, or in the context in which it appears, and a very broad definition of what is in the public interest, including the preventing the diminution of public confidence in the government, which is not a legitimate purpose under international law. These broad terms leave very wide scope for ministers to decide what content they want to correct. Failure to comply with a correction direction can be punished with up to 12 months. Website in which the directives in 6 months can be declared a declared online location, which severely restricts the ability to monetize the site. POFMA has been used approximately 83 times in the 2 years it's been in force, 53 correction directions requiring the person to make a statement inserting a correction notice within its published material. Generally a statement saying content contains false statements of fact. See here for the correct statements, the correct facts. The correction directions have been opposition politicians, activists, and independent media. Since I'm running out of time, I'm going to skip over some of the examples and just talk more about some of the problems with the lack of ability to really realistically appeal these decisions. Because given the penalties for failure to comply and the time and expense of appealing a correction direction, the law gives the government a tool whether or not a court would also serve with corrections, must post them or face criminal penalties, even if they disagree and even if they plan to appeal. And as for the appeal process, first to appeal to the minister who issued the directive. which unsurprisingly is generally not successful. You can then appeal to the High Court, but that requires payment of fees, days, the time and hassle of going to court, your lawyer's fees. Not everyone is willing or able to do that. So many people simply post the correction notice or take down their content, even if they don't think that their content was false or misleading in any way. The government has also taken the position that in an appeal, the person who made the statement has the burden of proving it's true. The high courts have split on that issue in the two cases they've heard to date. They heard arguments on the issue. The high courts have split. The Court of Appeal heard arguments on the issue and reserved judgment in September 2020, but a year later have not issued a decision. So there's still no clarity on who has the burden of proof in appeals, and no final decision on whether the two correction directions that were appealed, the corrections given the law's vague and overwhelming discretion it confers on ministers, the severe penalties and the lack of adequate redress, it's inconsistent with international standards for freedom of expression. And a number of states understandably called on Singapore to amend or repeal the law, but it declined to support those recommendations. Finally, I'd just like to briefly talk about other restrictions on media in Singapore. While print media in Singapore is largely controlled by Singapore Press Holdings, which is closely supervised by the government through the Newspaper and Printing Presses Act, online media has been the focus of independent media outlets. The government uses licensing requirements imposed by the Broadcasting Act, along with other regulatory restrictions, to impose content and other restrictions on online media, to restrict donations from outside Singapore for certain media, and to require disclosure of all sources of income. On September 14th of this year, the Infocom Media Development Authority suspended the citizen's license for alleged failure to fully disclose its funding using these rules, and the website is now disabled. In sum, while Singapore accepted recommendation, expression, opinion, and peaceful assembly are protected, laws that violate those international standards for protection of those rights remain on the books, and the government continues to use them against the country's few remaining dissenting voices.
Thank you so much, Linda, for also going deeper into the emblematic cases that really highlight the case of the restrictions on the mental freedoms in Singapore. We'll go to our third speaker. Our third speaker is Daron. Daron is a legal consultant at the International Commission of Jurists, implementing the Commission's projects on the right to freedom of expression and other digital rights, and the development of regional standards on freedom of association for workers in Southeast Asia. He has previously worked asylum access title. He holds a B.Sport, graduating with the first NS school, a Global Public Service Fellow, and a Harlan Fiske Stone Scholar.
Thank you very much, Joy. Let me just quickly share my screen. Can everyone see my slides? Let me try again. Okay. Oh. Sorry, I did something. Okay, all right. So thank you very much, Joy, for the introduction. So for my section, I will be discussing the Foreign Interference Countermeasures Bill. I think for those of us who have been following developments in Singapore, we're very aware that there is this new emerging threat to civic space, as well as human rights and fundamental freedoms. And so I will attempt to give a very quick introduction to this bill that's called Fika for short, and to highlight whether or not it is compatible with human rights law and standards. So before I do that, what is Fika, right? For those of us who may not be aware of this development. So Fika was introduced in Parliament for its first reading on 13 September. So this development took place 2 weeks ago. And based on the press release from the Ministry for Home Affairs, the intention of the legislation is to strengthen our ability to prevent, detect, and disrupt foreign interference in our domestic politics conducted through, firstly, hostile information campaigns, and secondly, the use of local proxies. The bill is likely to undergo its second reading on 4th October, which is next week. And so we can see that there is a very short 2-3 week window between the first reading and the second reading. And the bill is 249 pages long and has been described by Reporters Without Borders as a legal monstrosity with totalitarian leanings. So, sorry. So what is Fika, right? I have the privilege of attempting to explain 249 pages of this bill in 15 minutes, but I'll do my best. So what Fika, there are three main sections to Fika that I think we should be concerned about. And they're contained within parts 2, 3, and 4 of the Act. Part 2 creates criminal offenses related to clandestine foreign interference by electronic communications activity. Part 3 creates directions, gives powers to the minister to issue directions against harmful foreign online communications activity. And then part 4 also allows the minister to designate individuals as politically significant persons. For part 4, I will not be covering that. Kirsten, the speaker after me, will be talking about that. So let's briefly talk about what parts 2 and 3 mean, right? So what is part 2? What is this criminal offense that has been created? So for that, we can look at section 17 of the Act, and it creates an offense if someone undertakes electronic communications and publishes information in Singapore, firstly. Secondly, on behalf of a foreign principal. And thirdly, if the person knows or has reason to believe that this activity will be harmful, for example, if it prejudices national security, public health, or public safety, if it diminishes public confidence in the government or a public authority, or is likely to be directed towards a political end in Singapore. So that's the third requirement. The fourth requirement is if this activity is covert and involves deception. And so based on the explanatory notes, that means that it refers to any conduct that is hidden or secret or lacking transparency, for example, using encrypted communication platforms. And the result of this offense is that it may result in a fine not exceeding $50,000 or imprisonment of up to 7 years for individuals. So we see very, very serious criminal penalties there for conducting this activity. And I will talk more a little bit later about how this measures up to international human rights law and standards. Part 3. Part 3 creates, it gives powers to the minister, right, to issue directions against harmful foreign online communications activity. I think Linda's introduction to POFMA just now was very, very helpful, because I think in order to understand these part 3 directions under the law, POFMA will be crucial here, because basically what Fika looks like, what part 3 of Fika looks like, is that it's POFMA 2.0, except more serious and more, may result in the promotion of more censorship. So under part 3 of the Act, the minister can issue various directions under part 3 if he suspects or has reason to believe that someone intends to undertake online communications activity on behalf of a foreign principal, and that it is in the public interest to issue restrictions. So what we see in Fika is that the primary tool that the government will rely on under Fika is not correction notices or correction directions, aka what POFMA is used, how POFMA is used. And we can see how the government has departed from this pretense, right? Because under POFMA, the government would frequently argue that correction directions don't actually curtail free speech, since it doesn't require a false statement of fact to be taken down. There is none of that pretense of Fika. Fika will flat out result if the government issues any directions in the censorship of the material. So examples of part 3 directions include removing or disabling of access to online content, the publication of a mandatory message similar to POFMA, or the handing over of information for investigations into whether foreign interference has occurred. So that's for part 3. So what are the key concerns then for this law? Sorry. So the key concerns would be that the vague and overbroad language within the law would make it vulnerable to being abused by the government, especially given the vast amount of powers that this bill gives the government. We anticipate that it's likely to be used to unduly restrict the rights to freedom of expression, information, and association, as well as the right to privacy. And very troubling as well is the bill's attempts to curtail the role of the courts to review the government's exercise of powers under the law. And this is likely to severely undermine the rule of law. So if we want to do an analysis of this bill under human rights law, our starting point obviously has to be the ICCPR. And this does present some difficulty for us because, as most of us are aware, Singapore is not a state party to the ICCPR. But it's important for us to note that freedom of expression is a norm of customary international law that is incumbent on Singapore. Additionally, Singapore has also affirmed the Vienna Declaration and Programme of Action repeatedly, which means that it has agreed to be bound by these sets of rights. And also the protection of freedom of expression and other associated rights has also been repeatedly affirmed by UN Human Rights Council consensus resolutions. And so if we take a look at what's on the slide, right? This is drawn from Article 19, subsection 3 of the ICCPR and provides us with the standard in which it may be permissible to restrict freedom of expression. As most of us are aware, freedom of expression is a qualified right. It's not an absolute right. And human rights law is quite comfortable with recognizing that in certain circumstances, it may be necessary to restrict the right to freedom of expression, but it provides a very strict rule there that this must be done subject to the four principles. Firstly, the principle of legality. Secondly, the principle of legitimate purpose. Thirdly, the principle of necessity. And fourthly, the principle of proportionality. So that would be our starting point for looking at how this bill might be compatible with this standard under human rights law. So let's start with the principle of legality. What does that mean, right? So legality, the principle of legality means that the law requires that there is precision in the expression of the law. It requires that laws not confer unfettered discretion for the restriction of freedom of expression on those who are charged with its execution. And so when we have this standard and we compare it to Fika, we already see where the problems lie. Because I think if you've looked at the commentary on Fika, we know that Fika is very vague, it's very overbroad. And in particular, I would like to highlight two concepts that are particularly vague and broad inside the legislation. Firstly, the concept of foreign interference, and secondly, the concept of public interest. So let's look at foreign interference first, right? What does it mean to engage in conduct or to work on behalf of a foreign principal? And I have here on the slide the direct language that is used by the Act. We can see it's slightly opaque, it's very long, but some key forms of conduct that I would like to highlight would be, number one, that you are considered to be engaging in conduct on behalf of a foreign principal if you have an arrangement with the foreign principal, if you receive funding from the foreign principal, or if you're working in collaboration with the foreign principal. So we can see here from the language that it covers a very, very wide range of participation. And it covers, potentially an employee who is working for an international human rights NGO who is based in Singapore, or maybe even if you just organize an event with a foreign embassy or a company. And there is some precedence of concern there, because in May 2021, the Ministry of Foreign Affairs actually issued a statement reminding the US Embassy not to interfere in our domestic social and political matters after it organized a virtual book reading with Ugachaga, an LGBT organization. So we see here that it's very vague, it's very broad, and it can cover a wide range of conduct. Next, public interest, right, which is the purpose for which restrictions may be invoked. We see here the usual suspects: security, public health, public safety, but more concerning would be the diminishing of public confidence in the performance of the government, as well as to prevent any foreign interference directed towards a political end in Singapore. Again, very vague, very broad. It could potentially cover, any issue that has been of controversy in Singapore. For example, climate change, treatment of migrant workers, LGBT rights, women's rights. It's very, very broad. And so this brings us nicely to the next principle of legitimate purpose, right? Because when we want to restrict, if the government wants to restrict rights, it has to do so for a legitimate purpose. And this is a closed list under the ICCPR, which is based on the respect of the rights or reputations of others, or the protection of national security, public order, public health, or morals. We see already, right, from public interest, which is the purpose for which the government is intending to restrict expression, that the list of reasons there go far beyond what is within this closed list under Article 19 of the ICCPR. And there are just some examples there on the slide. And also another thing to note as well is that public interest is potentially open-ended as well, because the Act is very clear that whatever examples are given of public interest do not limit the generality of the expression. So potentially, the Minister of Home Affairs could invoke restrictions under Part 3 for a much wider purpose, besides those that are listed in the Act, as well as those that are permissible under international law. Necessity and proportionality, right? And I think this is where it's very concerning as well that we see criminal sanctions under this law. One thing that's interesting is that in the press release by the Ministry of Home Affairs, they glossed over entirely the fact that there are criminal sanctions under this law. So as I mentioned just now, right, section 17 to 19, clandestine activity would constitute a criminal offense under the law. And also not complying with any of the Part 3 directions would also result in criminal sanctions. And if we recall, under human rights law, criminal sanctions would constitute serious interferences with the freedom of expression and are considered disproportionate responses in all but the most egregious cases. So we see here how the law has many provisions that are not compatible with the right to freedom of expression and other rights, because it goes against the principle of legality, legitimate purpose, necessity, and proportionality. And it gives a wide range of powers to the executive. So usually one very helpful safeguard there, right, would be the role of the courts, having judicial oversight. And it's why the rule of law is important, and it's why the ICJ works very hard on this issue as well. But we see that the law deliberately curtails this role of judicial review and the role of the courts in providing oversight. So because I don't have a lot of time, I will have to gloss over this. Under the law, if you are issued with a Part 3 direction, your right to appeal is actually limited because you cannot appeal to the courts, but instead you have to submit your appeal to a reviewing tribunal instead. This reviewing tribunal consists of 3 individuals, one of whom has to be a Supreme Court judge, and is appointed by the president on the advice of the cabinet. And so what we see here is that the reviewing tribunal isn't actually a judicial body, even though there is a Supreme Court judge sitting on the tribunal, but is in effect an executive body, which means that this appeal process is still very much embedded in executive control. And furthermore, another very worrying thing is the limits that the law places on judicial review as well, because Section 104 is very clear that there are limits on the right to appeal to the court after decisions have been made by the reviewing tribunal. So decisions are considered final, not to be challenged, and they cannot be appealed against unless they are not in compliance with any procedural requirement under the law. And so this serves to limit the role of the courts and serves to undermine the rule of law, because it's very important that the courts are able to check the powers of the executive and exercising expansive powers under this law. So in summary, problems with this law and how it's not compatible with human rights law: vague and overbroad legal provisions, inconsistent with the principles by which you can restrict human rights and fundamental freedoms, and it's likely to infringe and restrict the range of rights listed on the screen, and we will also subvert the rule of law through the curtailing of judicial oversight. Thank you very much.
Thank you very much, Daron, for that very comprehensive look into Fika and how it is really concerning and its potential impact on fundamental freedoms and civic space in Singapore. And you mentioned also to that, and to go even to have Chris, who runs the newsletter We the Citizens: Human Rights, Politics, and Democracy. Kirsten?
Yeah, thank you for having me to speak on this panel. So as Daron said, I'll cover the one part of Fika that he skipped over for time reasons, and also because this, I feel, is the part of Fika that would really be the one that kind of has an impact and serious ramifications for civil society. So when talking about Fika, the initial focus that a lot of us have might be on the sections of the law that provide for criminal offenses, such as Part 2 that Daron talked about, which relates to clandestine publication of material online on behalf of a foreign principal, because the criminal penalties that are specified in that part are really harsh and really scary. It's, huge fines and long prison terms. However, the other provisions of Fika also have serious implications for activists, bloggers, journalists, and citizens. And in fact, my opinion would be that these are the provisions that would be more likely to be used more often to make life difficult for critics of the ruling party and human rights defenders. So, for instance, Fika allows an authority appointed by the Minister for Home Affairs to designate entities or individuals as they call it, politically significant. So political parties, MPs, election candidates will automatically be, deemed politically significant, but they can designate other people as well. And so this designation can then be used to regulate political donations or funding, as well as associations and arrangements between you and foreigners. And if you would like to challenge this designation, you can only appeal to the Minister for Home Affairs, who appointed the authority that designated you in the first place. If an individual is designated as a politically significant person, which can be done even if there's been no wrongdoing or offense committed, and in fact doesn't actually require any evidence of foreign interference or being a foreign proxy, and you will be subject to onerous reporting requirements relating to the funding that you receive and any affiliations or arrangements, which is defined very, very broadly. So like arrangements could be, or even any sort of unwritten understanding. So you have to report those, even if these affiliations with foreign principals do not relate to political activity in Singapore. This essentially recruits the individual into the state surveillance apparatus, requiring them to regularly report on their activities to the government. The government is also empowered under Fika to issue directives that would prohibit them from accepting donations from specific donors or to end affiliations with specific foreign principals. So failure to meet these reporting obligations or to comply with directives will result in criminal penalties. Given this situation, it's a real concern that people might be spurred to self-censor or self-police, either to avoid having to do these reporting requirements or to avoid getting designated in the first place. So once designated, you're just left at the mercy of the authorities to exercise their Fika powers over your work and your collaboration with foreigners. Although the government has claimed that Fika won't affect Singaporeans airing their opinions online or foreign media from reporting critically on Singapore, there are no such clear assurances or guarantees written into the law itself. Also, the speed with which the draft bill is being rushed through Parliament kind of shows that the Singapore government is not interested in consultation or checks and balances, even in the process of passing this law. So they've been looking at this law for 2 years, but as Daron said, the law was only first and it's expected to be up for its second reading and third reading on Monday. So civil society, we've tried our best to mobilize against this bill despite the very, very limited time. And so we've been trying to delay its passing and to demand meaningful public consultation instead. So given that it's unlikely that most people, and very likely possibly including members of parliament themselves, have had the time to read and digest the bill, we thought that we had to make it as easy as possible for people to understand what's in it. So we put together a website, which you can find at fika.sg. And this website provides a summary of the law and tries to answer questions that people might have about how it might affect them. We sent a letter to every single MP in Singapore asking to meet them so that we could share our concerns. Unfortunately, only 3 responded to us, and we ended up only meeting with 2 of them. Not surprisingly, every member of the ruling party has not responded to our emails. We've also shared a public petition on change.org calling for a select committee instead of trying to rush this bill through Parliament. The public petition has over 4,500 signatories and is endorsed by 37 arts and civil society organizations to date, which is quite something considering that there hasn't been a lot of public discourse and outcry about this bill in Singapore in general, because I think it's just happening so fast that people are not actually reacting to it in time. On this, we've also in the process of submitting a parliamentary petition via a non-constituency member of parliament from the Progress Singapore Party. Just before our session today, the Opposition Workers' Party has also said that they will be tabling amendments to the bill when it comes up for second reading, like on Monday. So yeah, amendments will have to do with things like trying to narrow the definition of what's in the public interest, narrow the definition of what trying amendments will probably be adopted because the PAP has a super majority in Parliament, and so that allows them to basically vote and push through any legislation that they like, and so they can just reject these amendments, but at least it kind of forces them to address these things. And that's generally sort of the best that we hope for in Singapore. So if Fika does have its second and third readings this coming Monday, it means that this extensive legislation would have been bulldozed into law just 3 weeks after it was first introduced in Parliament, with no public consultation, and despite misgiving from civil society and legal experts that have been aired in public via our petition, our social media posts, and op-eds in the media as well. And so we've already seen from past experience that the PAP government has no qualms about accusing critics as being disloyal to Singapore or to be agents of foreign interference if it suits them. So to give some examples, they've misquoted, in fact, a poem by a poet to suggest that, he doesn't love Singapore. They have denied registration to a media platform that I co-founded with 2 other Singaporeans, saying because we took money from Open Society foundations, essentially it's George Soros money and we're agents of foreign interference, so we cannot be registered to operate in Singapore. They've claimed that because the Online Citizen hires some Malaysian writers, then they're hiring foreigners to write articles that are critical of Singapore's government. So it's suggested as some sort of foreign interference. And so while they're not to name specific countries that they are concerned about in terms of foreign influence. So, if you look at their press releases, they don't actually name the countries. They'll just say a certain country, or like when we had bilateral kind of disagreements with a third country, a second country. They don't actually name the countries, but they do happily name local critics and activists. And so Fika then will put legal teeth behind these accusations, even if they're baseless, even if the suspicion of foreign interference only really exists in the ministers. Fika is ambiguous and overly broadcast this very, very wide net over a lot of activity that human rights defenders, activists, and journalists engage in on a daily basis. Particularly in a country like Singapore, that's so hyper-connected and has so many kind of global connections and implications. There are a lot of issues that we work on that would fall under this because of the nature of the issue. So, for example, young Singaporeans have been quite concerned about what this might mean for climate activism if they are wanting to undertake activity in solidarity with other countries in the region, and further there's kind of concern about what this might mean for LGBT activism, since the government has already invoked kind of rhetoric about, oh, you're importing culture wars, and foreigners cannot participate in the LGBT rally, pink dot, things like that. So there are all these kind of concerns about what falls under Fika. The past couple of weeks, there have been a lot of people asking questions to those of us who have gone over the bill, like, will this fall under Fika? And very often the answer is it's really up to their discretion whether they would like to exercise Fika powers over you, because technically advocacy work that would address a matter that's considered controversial or a matter of political debate that already is considered to a political end. And then if you have any sort of collaboration with a foreigner, whether that's an individual or an organization, then you're already kind of covered under Fika. So while most people would agree that malign foreign interference is something that countries and societies need to take note of and guard against, Fika's definitions don't restrict itself to insider meddling. Instead, it just grants massive amounts of power and discretion to the government, specifically to the Minister of Home Affairs. So that's another one thing that this law is so huge, but gives almost all the power to this one, the Minister for Home Affairs, to do what's right for Singapore. We only have their word for it because there's no meaningful independent oversight. So as Daron said, you don't get to go to courts. You only get to appeal these things to a reviewing tribunal that the cabinet president to appoint, or you appeal to the Minister for Home Affairs himself. The sort of uncertainty that feeds into a general atmosphere of fear and anxiety that would have a chilling effect over Singapore, as if we don't have enough chilling effects from all the different sorts of laws that you've heard of from the previous speakers. And so this would then disincentivize Singaporeans from trying to engage in expression, association, and activities that we should be able to do by right. And it's a reminder to Singaporeans that instead of speaking up to address injustice or to the democratic state keeps be, if we follow the language of Fika, politically insignificant. Thank you.
Thank you so much, Kirsten. Thank you so much, Kirsten, for also highlighting the real-life impact of Fika and also the broadness of the language that would have disastrous impact on fundamental freedoms. I think at this time we will open the floor for reactions and questions. And perhaps if I can request our speakers to turn their cameras on, if that is okay. We have been told that our colleague Sammy would also like to react to the speakers. Sammy, would you like to, we will give you access. Would you like to speak? Perhaps if I can ask Sammy to have access. You.
Thank you. It was not muted earlier. Okay, thank you for this opportunity. I think the four speakers have provided quite adequate background information. And I think we should thank them for expressing themselves, especially Kristin, who is based here. I hope so. Daron, as well as the other two. I think Hanung, Daron may be based in Bangkok or Hong Kong, and ICJ is in Bangkok. I'm just saying the location because knowing that three of them are outside Singapore and one person is a bit difficult, I mean, for people to understand. From what people may have heard, Singapore is a heavenly shopping center. And it is right, it used to be a heavenly shopping center before 2019. Even human rights activists from other countries, UN agencies, also members used to stop over Singapore either for their visa and shopping. Yeah? That is the reality. But when you ask them to talk about human rights, of course, it is a bit frightening. In fact, I've told UN officers when they visit here, they need to meet with the foreign ministry. No, they cannot just come in and talk, because what applies to Singaporean also may apply to them in the sense that if they don't speak to the government that they're coming here on official purpose, there will be difficulties after, whether it's a UPR process or any other process. So that is one of the reality. My camera somehow is disappeared. I think I can't see my own face in the computer. If you want to, you can on. I'm not afraid of showing my face. That need to be known. That's one of the reasons Think Center is here. That if you cow down to this process and hide yourself, it just shows that you have so much fear that you will not speak to the system. That's something Think Center, when it's very beginning in 2001, we had a position that we should show our face and we should speak to them directly if possible, if they allow it. If they don't, then we use other ways to express it. But don't turn around our back and run away from these issues. Of course, it's difficult. People will say, even in Think Center, people who were afraid of losing their livelihood or becoming punished in a way that's how they lose their livelihood. They're not given jobs. The employer will say, are you from Think Center? They may not employ them. So you see, the pressures are not only from their own families, but from future employers or the current employees. So there are very few who will employ a person who's actively, openly advocating human rights or have a different view from the system, the political system that is the ruling party, the PAP party. And we know what happens to the opposition, how J.B. Jerathnam in the 80s and 90s was humiliated, abused, and finally died, after he finished his parliamentary term. He was the first opposition parliamentarian after 60s to be elected. We also know under ISA, which was brought by the British in the 60s and 70s, a lot of people were arrested, and Chatapa was in prison for more than 30 years. That's very cruel, in isolation most of the time. So you can imagine those things are used to until the last big arrest. It was in 1987, mostly from church and civil society groups. They were also arrested and locked up. These were all to frighten the people from coming out and speaking their voicing. But today we heard the new law Fika is coming out. Now I think we are being told, don't open your mouth if you can. I'm not sure how much time do I have, but just give me a few more minutes, I should finish. So my issue is that in that situation under Fika, of course, we cannot sit with a foreigner, whether from any country, individual or organization. And in this situation, it also comes to our mind, UK is a colonial power which brought in the law, and they are a good friend of Australia and New Zealand. How far would they help civil society? We have a big question mark. The US, the largest imperialist in conflict with China and Russia. You think they are going to help a small Singaporean? They want to do business with Singapore. And lastly, I would like to say, Singapore is a very good influencer. They are good in language, in English, everything. They do influence many ASEAN countries and developing countries. Keep that in mind, because that means many of these countries would be clapping for Singapore and not its citizen or even the migrant workers here. When they are abused, when they are not paid, when their own countries would not openly support migrant workers' rights. Migrant workers are discriminated, women are discriminated in their pay, and gender discrimination is still ongoing. So there's no minimum wage in Singapore, by the way. So I would not ramble on too much, but the fact is that even human rights groups outside Singapore would not visit Singapore now, that's clear. But on the other hand, would they speak for us even? I encourage them to speak for us. And for all their human rights stand, to stand with the Singapore people. Of course, they have to stand with the Burmese people too, or Myanmar people. They are under worse situation, physical violation, even being killed. And not only in Myanmar, people are also being killed for human rights and other issues in other nations around Singapore, Philippines, Indonesia, Thailand, even for land rights, even in Cambodia. So we need to look at ourselves. How many of these countries would be happy with the position Singapore has taken? Nobody is killed here, but people are shut up by the law, long-term imprisonment, and the heavy financial burden when they are for defamation or any other suit, even under FIACA. Fika. No? So I think these are things that actually doesn't free a human being. Actually, it abuses the human being to a level he or she has to bow down and surrender. That's what they want. So what our civilized society or modern society we are in, and those countries that are trading with us, this is my last point, free trade agreements are one of the portfolio Singapore likes to accumulate and tell the people, look here, I'm trying to bring in more jobs for you guys, more income for you guys. But the point I'm trying to say is this country has a human rights question mark on their head, just like Myanmar. Of course, it's a worse scenario. So in this scenario, we will never see UK or US trying to inform Singapore, hey, don't do this. No, it's not good for human rights. No, they want to make trade agreements. So do other countries. So I have a very tough situation here in Singapore, and I think many people have. And I hope human rights group will think of new initiative, new ways, how to work as a region within Southeast Asia and beyond. Now, of course, the government has warned us, don't sit with others, but they also wrote in a letter to a few days ago, you can talk to them as long as they are not strong enough to influence you. Mind you, I would like to say this last point, this important point. Singaporean people like in Think Center and others, we have our own mind. We can think for ourselves. Why should we blindly listen to anyone, whether it's the US Open Society or anywhere, or the US government? We have our own brains. We can think for ourselves and we can make our own decision. Please do not look down so much on us that only the government and the ruling party can think and not the people, the citizens. So I would still welcome all friends in Southeast Asia and beyond to keep dialogue with us and keep dialogue with the Singapore government too. And I think that is all I have to say. And thank you for this opportunity, Forum Asia.
Thank you so much, Sammy, for also raising that. Perhaps I'll go with the questions. We have some questions that came up. So one is, over the years, improved or worsened or stood, what is the future? We can ask our Singaporean friends, perhaps Kirsten, if you want to go first. Or
Yeah. I think in recent years, the situation has kind of tightened. So we see with laws like POFMA and Fika that is basically just all these really broad laws that are being passed that cover all sorts of activities. So and then it basically just leaves it up to the government's discretion how they want to use it. So, you know, it kind of is kind of up to them and optional. So while it might look like they're not arresting everybody and there's not, you know, very kind of attention grabbing sort of actions, what there is that all these things just kind of dangle over your head, and so that encourages people to self-police and self-censor because you know that they could use it against you. It's just a matter of whether they want to or not. So a lot of energy then goes into trying to act in ways or to convince the government that they don't want to act against you, and that it, you know, you're really nice actually. And then there are civil society organizations that are very split on like what the strategy is to government. Some are more adversarial, but a lot of other ones are also, you know, play nice a little bit because there's all these uncertainty hanging over your head, right? So that kind of pushes people to make all sorts of decisions and compromises without the government having to do very much. And you know, it just becomes entrenched in the system and we do it to ourselves.
Maybe I could just add very quickly, also sharing my perspective as a Singaporean. Yeah, I think how the government responds to dissent in the country, right, has always been based on this idea of calibrated coercion. So like Kirsten mentioned, you know, we don't have very outright cases of extrajudicial killings. You know, we don't see, you know, masses of people getting arrested and detained. But what we see is this, maybe more insidious form, of encouraging people to self-police. And I think definitely over the past few years with POFMA and now with Fika as well, we see this increased concentration of power in the executive. And we're just almost expected to trust that the government won't use it on the people, even though these laws are very, very broadly worded and can essentially cover a very, very wide range of critical comments and dissent against the government. So I think, this is the trend that we're going to see going forward, right? We have POFMA, we have Fika. Who knows, we may have similar laws that, draw from the powers, that take inspiration from these two laws that we've seen. As the expensive powers on the people, I don't think the rule of law.
Thank you very much, Daron. We'll go to another question. So Singapore often claims its circumstances are exceptional and its commitment to human rights must be subjected to public, and that its approach to rule of law is suitable to protect human rights of Singaporeans. This approach is a fundamental obstacle to improving our civil, political, and social economic rights. How can the international community help persuade Singapore to align more with international human rights standards? Also sharing that we are joined by friends from the international community from both Singapore and Geneva. Thank you. Perhaps I can ask Linda or Hanung to take this on. Who wants to go first? Hanung, you want to go first?
Yep, I think I can go first on what the international community should do, and also link into the UPR, because we're talking about today. And then, as I mentioned, that UPR is actually a political commitment, but again, there is no commitment right from the start. Then from the country concerns, or maybe from the member states to monitor together. So it's really hard for a country to hold on into account if related to this. And 2 cycles, Singapore keeps committing to ensuring the human rights will be protected in the countries. But in the previous cycle, in 2019, they adopted POFMA, and then later on, 2021, they're discussing to have Fika. And if Kirsten mentioned that if Fika really will be a law, like if within a month or even this year, then again, sorry to say that Singapore has been failed from the start on upholding its commitment to the UPR and the recommendation that they have ratified. And then, so having these cases, international, I think it's to have to show a more, to show a stronger position, stronger language on criticizing Singapore, either using a UPR mechanism or other mechanisms, like relying on a very diplomatic word PR. They're quite real that certain countries will to be put aside, and because this is more getting serious. So therefore, my call for international communities to push for stronger language and recommendations, and use the international avenue and give place and have a dialogue with civil society on the ground to align the messages as well, and to hold Singapore actions for filing its commitment. And it's kind of like a $1 million question, and it also makes me start to think on how to advocate for this, and also to give her more protections for human rights defenders.
Thank you so much, Hanung. Linda, do you also want to share anything to add to that, or?
Just briefly, I definitely, second the idea that governments need to be more assertive in how they deal with Singapore. Singapore often seems to sort of get a pass. It's like people think, oh, Singapore's it's clean, it's a good place to go, as Sammy said, a good place to go shopping, and they don't look closer than that. And I think there also is a tendency from some countries, because Singapore is a partner in security and other things, not to want to push Singapore too hard on its rights issues. But that's really unfair to the people of Singapore, because the people of Singapore deserve the same rights as people in every other country. And so the international community in pushing for rights should push Singapore just as hard as it pushes other countries, and not be sort of blinded by the fact that Singapore superficially looks, very, clean and rights respected.
Thank you so much. I think we have time for another question. It's a bit related. So with Singapore rejecting recommendations, including criminal defamation, how can the international community use the UPR process? Does anyone want to take that on? It's mostly related to UPR.
UPR is to see that all of the recommendations are noted, basically are rejected. But when they say noted, is they actually don't want to show a political commitment on it. It doesn't mean that they will kind of fully reject it, but it's just they want to show that it's a safe zone for them to say that, okay, we don't want to commit anything related to it. So basically, there's still like hope, if I can say it's a hope, that a dialogue for international communities or civil societies from Singapore and from the regions coming together for the review or repeal of certain legislations that are very restrictive for the fundamental freedoms. I think practically, but this is something that actually we as a society from all over the world actually can do to hold Singapore.
Thank you so much, Hanung. We have 5 minutes, so I think I will need to wrap up. I would like to thank everyone. I'd like to thank everyone for participating here, but also wanted to thank our speakers, and also just a very quick wrap up. So Singapore has continued to arbitrarily restrict its people's rights, despite recommendations from the previous cycles of the PR. Hanung and Linda also raised how the government has continued to crack down on the rights of activists and journalists and artists. And Dan and Kirsten also raised the potential impact of the Fika, which is being railroaded, and also how the breadth of its scope can actually further impact. And then Singapore in its UPR response has shared that they do need to prioritize the need for a harmonious society, but also we would also like to remind Singapore that preserving a harmonious society or ensuring an inclusive society also requires the guarantee of fundamental freedoms. I think we have time for one last round of last messages from our speakers. Perhaps if we can limit it to 30 seconds or so, just final messages. Perhaps we can start with Hanung.
Okay, can you hear me now?
Yes.
Okay, the internet. Yeah, I just want to add from a previous point that UPR actually used for 4.5, that if they don't receive positive recommendations at this moment, it doesn't mean that they're not going to receive any recommendations in the future. So this is the beauty of the process when civil society and international community comes together and to monitor together on the commitments and the progressions that Singapore made during the UPR process. So I guess investing in the UPR process is still worth to be conducted. And also, I would like to show my solidarity for people in Singapore and for Think Center as well on the current situations that they're facing. Thank you.
Thank you so much, Hanung. Daron, you want to go next?
Sure, yeah. I mean, I didn't have a wrap-up planned, but I think just off the top of my head, I think really what we can do is just to continue resisting, right? If we see the passage of these new laws, that are incompatible with human rights law and standards, push back against these things, both from Singapore, the international community. And even though I think Singapore tries very hard to distance itself from the language of human rights law and human rights standards, I think, human rights law still provides a very, very good starting point and basis for analyzing, some of these laws that are coming up from Singapore. So I would definitely using the human rights language to look at developments in Singapore. Thank you.
Thank you so much, Daron. Linda?
I pick up a little bit on the point about supporting human rights defenders in Singapore. I do think it's really important, particularly with Fika now and the possibility that those trying to service might be designated repercussions for dealing with the international community, that the embassies and international NGOs and others find ways to support activists acting within without also increasing their risk. And I think that that's a balance. And I think part of what Singapore, the government is trying to do here is to essentially push out international like INGOs and others from speaking out on or working with local activists to speak out on issues. But I think it's really, really important that the international community continue to stand by the activists in Singapore as they.
Thank you so much, Linda. Kirsten?
Yeah, I think thank you for this session. I think just continued attention and documentation of what's happening in Singapore is very important, because they much as the government likes to say that they only do what's right for Singapore and they don't bow to pressure, they are very, very sensitive about what their international image is and what their international reputation is. So to have people who actually pay attention and not let Singapore get away with these things continually is very important. So I think I'll probably just end with that.
Thank you so much, Kirsten. Also reiterating the message of our speakers for our international community colleagues and friends to help protect also as Linda mentioned, the human rights defenders who are also speaking at great risk to themselves and to their organizations. So with that, I would like to thank again our speakers. Hanung, Linda, Daron, and Kirsten, and also the organizers of this event, Forum Asia, Civicus, ICJ, Access Now, Think Center. And also I'd like to also thank helping make this happen in Access again for staying with us. And yeah, we hope to see you around. Thank you. Good evening and good morning to everyone.